Right, guys, I just want to do a mic test. So radio mic's working, that's good. And we've also got the lectern mic. Alrighty, okay, let's get started. Really glad to see people have come to the lecture, so well done. I know it's a busy time of the semester, and I've been commenting to some of the pracs today how, it's a little unfair to call it a mid-semester break when no one gets a break. But I thank you for coming along, because this is all fairly vital components of the course in terms of being on the exam, and it does really help your learning in terms of, being in the lecture and giving this time to process between now and when you do the exam. We're looking today at the second part of the Queensland Environmental Protection Act, and we're looking at it particularly from the point of view of contaminated land and how to manage and respond to contaminated land under the Queensland Environmental Protection Act and under the Department Environmental Enforcement guidelines. Now, you'll become quite familiar with those guidelines. You need to have a copy with you for the exam, and during one of the practicals, you will be doing an exam scenario using the Department of Environment Enforcement guidelines as well. So as of next week, we start getting into exam preparation mode in those practicals, and each week we will do an exam scenario. 2 of the weeks we'll do an entire exam, 2014 and 2012. But obviously the quality of the learning you get out of those pracs depends on the amount of prep that you've put in. So make sure you've downloaded the information for the prac, you've read over it, you've considered, a dot point outline, really come in ready to be part of the discussion. And then you'll get the most out of it, and it will really help you to be in the right headspace and have the skills that you need to do well in the exam. I put a notice up on Blackboard today just reminding you of the process for getting the assignment in. So the discussion board is going to close at 4 p.m. on Monday. So if you have any queries about the assignment, make sure you get those queries in ahead of time. And the reason for that is your assignment's due on Tuesday, and I'm in back-to-back teaching all day Tuesday, so there's no point posting to the discussion board because I'll be teaching. And our pracs from next week move on from the assignment, they move on to looking at the exam prep, so we won't be dealing with the assignment during those practicals next week. In terms of your cover letter to the client, make sure that under your signature you've put the full name and the email address of each of the members of your group, so it's clear who each of the members are. And what I've asked is, once you've submitted it via Blackboard, send me 1 email per group with the CC, all the email addresses of everyone in the group. Send it to me just saying, we're in this course, so either the undergrad or the postgrad course. These are our names and we've submitted. What I'm going to do is I'm going to use that as the assignments come back in and they're marked, I'll progressively release the marks and the feedback back to the students. So you'll get an email back from me saying, hi group, here's your mark, here's your feedback, and that way you're going to get it ahead of time before we start sitting the exams and so on. So from my point of view, that's more efficient than waiting for the iMark system to release your marks back to you, because that sounds to me like that will take an eternity. So you will eventually get an official message back from iMark, but this is we'll get it to you more promptly, and I think that's more helpful to you. Are there any general questions that you want to ask me about the assignment while I'm here? Yeah. Yeah. The self-assessment sheet? Yeah. And that's 1 per group. Someone asked me the question of how many times do you fill out that self-assessment sheet, and you just fill it once per group, so you have to come to a group decision on what you think your assignment's worth. So not signatures, Names. Yeah. But you don't need to be signing it. You just need to make sure the full names are on. So in the past, when the assignment was done, each group was given a number, and so they went by an identifying number instead of names. But I haven't done that this semester. So we just need to make sure that when the paperwork comes in, because it's only uploaded by one student, we just need to be sure the paperwork makes it clear who everyone in the group is. Yep. So we've talked about the tutorial format. Does anyone want to ask me about the tutorials? Or you just wait and see what they're like? The Friday morning pracs, I told you guys this morning, but there'll be a new tutor taking over from next week. Cara Thompson will be running the Friday morning practicals for the remainder of the semester. So she's previously tutored in this course with Chris McGrath, and she's going to be helping to prepare the Friday morning pracs for the exam. So I'll come along to the pracs and introduce Cara to the groups, but just to give a heads up for anyone that wasn't there this morning. My slides are a little bit rougher than usual. I had a very sad moment yesterday morning when I went to upload them to Blackboard, and the file just disappeared in front of my eyes. It became corrupted, and I lost all my slides. It was a very sad moment. So if you go through and you notice typos and things like that, yeah, bear with me. You have slides. That was a challenge. So we have them, but yes, it obviously didn't like something that I had integrated into it. So what are we doing today? So today we're looking at the powers of the Queensland Environment Department. Now, for the postgrad students, you will know, if you look at the information for your exam, that you have an essay question on this, an optional essay question on this. For the undergrads, you'll find that this will come in terms of a short answer question and or multiple choice questions. So you'll find it in different parts of your exam. So it's applicable to both courses. But for the postgrads who have more essay-style questions in their exam, it's also one of the categories that's there for them to select. So to refresh the lecture that we had before the break, you remember we talked about these definitions, and we went through a little bit of a statutory interpretation exercise, pulling out the key components of the Act. I'd highlighted some of the wording for you, so you could start to learn to sort of skim and absorb the key provisions. So we looked at the definition of environment. We looked at this concept of environmental values, and then how that was incorporated into the definition of environmental harm and nuisance. And of course, the next step from that is to say, well, is it unlawful? Because not all environmental harm is unlawful. And one of the things that they look at is this idea of the general defence, whether there's a general defence to possible offence provisions, and you say, well, has there been compliance with the general environmental duty? And again, for those that were in the lecture last time, I pointed out that, again, that's something that you would expect to see an exam question on, this idea of what would you have to do to comply with the general environmental duty. So today we look at contaminated land, and we look at the consequences of contaminated land, which is that it leads to restrictions on the ability to deal with the land. And we talked at the beginning of the last lecture about the Abbott Point coal terminal spill. And this is an example of observable contamination. It was very obvious in the footage that, in the before photo, which is the one on the left, we have greenery, we have wetlands, and then a very obvious pollution event on the right-hand side in terms of the very conveniently black-coloured coal-laden water discharge. Now, for something like that, that was picked up on satellite imagery. So everyone was onto it very quickly, asking, well, hang on a minute, why is the coal terminal allowed to discharge this water? And one of the things that was not made clear in the media at the time was that it had been authorised by the Department of Environment through an emergency temporary emissions licence. So these things can be triggered when there are particular events, and of course in this case we had ex-cyclone Debbie causing huge volumes of rainfall. There was, potential flooding on the site, and so they applied to the department for a temporary emissions license. The question that then became was the temporary emissions license that was issued, did that cover what was actually discharged? And one of the questions that hasn't been answered yet is whether the amount of particulate matter, if you like, the amount of coal matter in that water, exceeded the limit that was permitted under the temporary emissions license. So something like that, yes, it's contamination, it's pollution. Is it unlawful? Well, of course, jury is still out on that. It depends on whether they breached their temporary emissions license. And we won't know that until the results of the Department of Environment investigations are made public. But really, when we're talking about contaminated land under the provisions we're going to look at today, we also need to think about those sites where it's not obvious from looking at it that there's contamination. I used to do a lot of work for Shell and BP and all the other various big oil companies working with contamination of their petrol stations. And it wasn't the petrol stations themselves that were the concern. Everyone knew that they were contaminated because they had petroleum leaking from their underground tanks for decades, until they got better quality storage systems and monitoring systems and so on. The issue was not the site. The issue was the plume that migrated underground from the petroleum, the petrol station site into nearby housing. And so I would sit and do my Google Earth desktop study, and I would say, is this petroleum station on an incline? Is it on a hill? And then we would track it downhill to see how many houses had contaminated land as a result of being situated near a service station. And I had some brilliant photos to show you where we were going to talk about the surrounding area and which of the houses you thought were potentially contaminated, but that is obviously what corrupted my PowerPoint slides. So that's what I was doing late one night, and clearly it didn't like it. So today we're looking at something that's not Queensland-based, which is unusual. Normally for the case studies in this course, we try and keep it in Queensland. The reason we're turning to Sydney is because it is such an extraordinary story. It's almost an outrageous story. And it's also a story of difficulties and challenges and complexity. And that's why we're using it as the case study. The actual legal provisions for Queensland are fairly straightforward. They're quite easy to understand. They're quite easy in their application. But it's just interesting to look at a scenario like Sydney Harbour and look at what happens when pollution is allowed to get out of control, and of course what happens when it's cumulative and it's hard to track back to who was the original instigator of all this. So you can have a look at more detail for this if you're interested. It's theconversation.com, and Chris McGrath wrote an article on it about Sydney Harbour because he'd been, of course, using the case study in the course here. And it all got triggered by a trip to Sydney with his family where he picked up the local paper and realised that there was an outright fishing ban for any fish caught west of Sydney Harbour Bridge. And many fishermen, being sort of, residential type fishermen rather than commercial, weren't aware of this fishing ban and were going out and happily collecting these fish and taking it home to eat. Now, that ban, you can see here, this is the Sydney Morning Herald, and this is from 2010. And it says harbour dioxins hit critical level, and it lists the official warning for the type of toxic fish that must not be eaten if captured west of the bridge. And this was the result of contamination that had leached into the harbour and had really got so out of control that it was posing health and safety concerns for the community as a whole. So it said in the article, this is it in the sort of electronic form, that the fishing bans would stay in place for decades to come. This was in 2010. And this was despite the fact that there had already been one remediation of Homebush Bay at the time. And they said that it was just because the area was so large, as in Sydney Harbour, and the sediment had spread so far across the harbour that it was just physically impossible to go and remediate the area. And the problem is that, you know, these fish are in the harbour. It's, you know, their habitat area, and they're absorbing what they're calling poison. So why did we have this problem? Well, of course it comes back to historic pollution, unregulated pollution. And in this case, this is showing the history of the site. So 1957 to 1971, there was a manufacturer on the site called Union Carbide, and they were producing chemicals associated with Agent Orange. And although at the time the EPA was issuing them with notices, so the EPA at the time was aware that the pollution was leaching into the site, they did attempt to issue remediation orders to Union Carbide, and they had no response. So there was this knowledge that the process was toxic. There was knowledge that the pollution was occurring, but what they didn't have was knowledge of what to do about it. And in fact, there was a whole row of manufacturers side by side along that bay. Obviously, the Agent Orange chemicals were the worst, but the ones either side of them were still producing some fairly nasty things. And they were all contaminating the land, leaching things off site, and so there was this cumulative impact that was going into the bay. And what the government did not know what to do is they did not know how to remediate. Physically, they did not know how to remediate it. And so even though they've known since the 80s that the site was contaminated, and they've probably known since the late 90s that the harbour was contaminated as a result and that it was posing a risk to health and safety. But what they didn't know was how to bring all that together and actually bring in the technical team to remediate. And when I worked in Sydney, it was in the early 2000s, and I was part of a public inquiry that was held into the remediation of Homebush Bay. And being a fairly junior person at the time, I was doing sort of research in the background. I didn't get to go to the inquiry or do any of the cool things. And so I wasn't that interested in it. I'd sort of do my research and move on to something else. It was only when I came back and looked at Chris's case study that I realized I'd been part of the public inquiry that had decided how to remediate Homebush Bay. So we had acted for TEAS, which was the company that eventually got the contract to go out and remediate based on their recommended procedures. And so they had obviously hired the lawyers to represent them to make sure that they got their best submissions in terms of they had a history of remediating difficult sites. So just to put it in context, you've got Sydney CBD, the Harbour Bridge over here. I used to work just near the Harbour Bridge, near the rocks there. It was very nice. Have you ever heard of a book? You probably haven't, but every law student has heard of a book called Hell Has Harbour Views. Because if you work in the big firms in Sydney, your office has harbour views, but you're in hell. So Hell Has Harbour Views, that was me. And then the Homebush side is well over there to the left, about 12 kilometres away. This is a sort of image of what the peninsula looks like. That's taken in 2005, so that would have been around about the time that they started that remediation process. And one of the things that happened, one of the reasons why the contamination caused so much difficulty is they reclaimed areas of the bay to build on for these developments, for these manufacturing sites. And really, of course, that caused some of the problems because they weren't going off the most stable ground soil, and so there was a lot more leaching back into the bay than you'd otherwise would have seen. And you can see there images from the 1930 up to 1970, and that's come out of one of the technical papers that would have been submitted to the inquiry. This is the chemical company itself. You can see it doesn't look too bad from the outside. And this is what we were talking about. I think we talked about it in one of the earlier ones when we were talking about planning. How you have to sort of you have to have that cynical sort of question mark when someone comes to you and says, "Hey, we want to develop this site," you know, la la la. You know, when something like this has taken place on the site, you should sort of be flagging in your mind, contamination. Should we be investigating that? Should we be asking more questions? And we'll talk about that more when we talk about the ethics lecture and the professional duties lecture right at the end of the course, because it can often put you in a difficult position, particularly if your client is saying to you, "No, don't look into that. No, you don't need to worry about that." Usually that's when the alarm bell should be ringing that, well, maybe we just need to, you know, close that off and do the investigation and get the full answer rather than just assuming nothing sinister has happened on the site. So more images there of the chemical company. This is a list of the chemicals that were produced at the site. Yeah, you can see DDT is there, formaldehyde. You know, nasty stuff, really particularly nasty stuff over a long, long period of time, 1928 through to 1986. So production ended at the site in 1986. So when production ended, they demolished the site, they partially remediated it, they sort of covered up the soil essentially, so put a layer of soil over it to sort of close it, but didn't deal with anything underneath, and of course that continued to leach into the bay. You can see all the massive storage barrels there. You know, none of this was done using, if you like, modern standards of what we would call decommissioning, remediation. And it left a very, very expensive bill for the government to pick up when they finally made a decision on how they were going to remediate the site. This is what I was talking about with the partial remediation. So they just covered up some of the soil, bought new topsoil and things like that. Again, this is back to the Sydney Morning Herald, looking at the different danger levels, looking at the different levels of toxicity as it runs down the rivers. You can see the widespread across Sydney. You know, this was a far-reaching sort of consequence of the contamination, and it really concerned a lot of locals who, up until that point, had not been aware that they weren't meant to be, you know, eating the fish that they were catching in the bay. So there was a lot of community outrage that this was being allowed to continue, that it wasn't being addressed. And the reason it wasn't being addressed is they were waiting for the latest technology to come online that would allow them to remediate such a large-scale area. That's why they waited, and one of the slides that I wanted to show you was an academic that commented on, you know, why waiting matters. And while it was all well and good that ultimately TEAS was able to remediate the site using the latest thermal processes, in the meantime, so much damage had been caused by waiting. And he was pointing out, I suppose, the difficulties that regulators had faced in this case, but also perhaps also criticising the fact that they should have been more prompt in how they dealt with it. So you can see the widespread. I mean, the pollution side is up here, and we're seeing pollution all the way down, 12k away down in the Sydney Harbour. So there was a real leaching event. Again, this is more news footage. This is from 2014, so quite recently, again, pointing out that anglers were ignoring Sydney Harbour health warnings, and they were pointing out the fishing hotspots and saying, don't eat the fish from the fishing hotspots. Again, signs were going up. Recreational fishing dietary advice. Due to elevated levels of dioxins, fish and other crustaceans caught west of the Sydney Harbour Bridge should not be eaten. You should release your catch. For fish caught east of the Sydney Harbour Bridge, you should generally not eat more than 150 grams per month, and so on and so forth. So, yeah. And then we had people calling for the government to carry out widespread testing of recreational and commercial fishermen who've been exposed to this water and exposed to eating the fish and so on. And yeah, there was certainly a significant amount of community concern. So what's the takeaway lesson from this as a case study? Well, definitely, it is fair to say, and it's not in any way, wussy to say that environmental regulation is hard, and particularly a case like this. Managing and regulating the site, it's difficult, it's complex, it's technical. And something like this, the activities are spanning decades, and what we have is severe cumulative impacts of long-term effects. And that was scary for the government. They don't tend to hold public inquiries in Queensland, but in New South Wales they keep them for almost like we talk about matters of state interest. It's a little bit like that. It was for something that is so crucial to the interests of the whole of New South Wales. That's when they go to the expense of holding a formal public inquiry. And everyone was so concerned that they held a public inquiry just to decide whether they should remediate and how they should do it. That was all the inquiry was looking at. It wasn't about pointing blame and claiming costs from a company that no longer existed. That ship had sailed decades before. It was just about getting community consensus on what technical know-how do we have here? What are the remediation options available to us, and can we afford it? And one of the remediation options included burning the material on site. Now, that caused real community concern because it was then going to be, if you like, aerated. So you then had a problem of whether or not you were going to cause more pollution and more health concerns to local residents by burning it and allowing those particulates to spread. And so really a lot of the inquiry is focused on what type of remediation would be least hazardous to the community. So keeping that in mind, let's have a look at what the Queensland Environmental Protection Act tells us about contaminated land. Well, the first place you should always start with these things is what is contamination? Just like we started last week with what is the environment. So what is contamination? Contamination of the environment is the release, whether by an act or omission. So that means whether because you deliberately did it or whether because you deliberately didn't do anything to stop it, of a contaminant into the environment. And that contaminant can be a gas, a liquid, a solid, an odor, an organism, and energy, including noise, heat, radioactivity, electromagnetic radiation, or a combination of contaminants. Now, I used to write a paper long back when greenhouse gas was still, very new and people were looking at it, pointing out that the definition of contaminant here is broad enough to extend to greenhouse gas emissions. There's no question that when we talk about contamination under the Queensland Act, contamination could include the release of greenhouse gas emissions into the atmosphere. So in this case, we've got this leaching of liquids off-site, so that's a contaminant. Then we want to say, well, is it unlawful? Because, of course, you need to look to the offence provision. So one of the offence provisions tells us that it's an offence to place contaminant, is the way it's worded. So a person must not cause or allow a contaminant to be placed in a position where it could reasonably be expected to cause serious or material environmental harm or environmental nuisance. And you'll remember we looked at those definitions in the last lecture of what is serious environmental harm, what is material environmental harm, and then what is environmental nuisance. The wording is interesting. So it's not just this idea of deliberately flushing something down the drain into the waterways, but just leaving it adjacent to a curb where if there's a rainfall event, it can wash it down into the drain and then on into the stormwater system. That would be enough of being an offence of placing a contaminant. And when you do the exam scenario next week's prac, you'll be looking at an example like that. In fact, it's an example where someone was prosecuted for it. Oops, wrong one. Here we go. It's also an offence to release or cause to be released a prescribed contaminant, so that's set out in the environmental protection policies and the regulations under the Environmental Protection Act, other than under an authorised person's emergency direction. So, when we have these heavy rainfall events and so on, you can go and get an emergency direction from the Environmental Protection Act that will authorise what would otherwise be unlawful. But otherwise, it would be an offence to do so. They also have a separate provision for water contamination because it's such a key issue Probably in every state, but certainly in Queensland we see it as well. So they must not unlawfully deposit a prescribed contaminant in waters or in a roadside gutter or stormwater drainage. Again, you'll look at that in the prac next week. Or at another place or in a way so that the contaminant could reasonably be expected to wash, blow, fall, or otherwise move into waters or into a roadside gutter or stormwater drain. So you can understand they're trying to catch those scenarios where there's negligence, where someone has been reckless, where someone has just failed to take reasonable precautions, and then it has ended up in the stormwater system or the drains. And so it makes it easier for the Environmental Protection Agency as a prosecutor to prove that there's been a breach of the Act. Because in this case, they're not having to prove that harm has been caused. They're just proving that it was deposited in such a way as to run into the water. And that's a much easier standard of proof to meet. What happens if you have contaminated land? Well, there's a duty to notify. There's a couple of duties, but one of them is the duty to notify under Section 320A. And I mentioned to you in one of the lectures before, this now applies to auditors. Previously, auditors fell into this little loophole under the Act where they might go out, audit a site, recognize that it was contaminated, and they didn't have an obligation to tell anyone about it, only to report back to whoever their client was that had engaged them to do the audit. Now there's an obligation to tell the owner, to tell the occupier, to tell the department. But equally under this provision, if the owner or the occupier of land becomes aware either that something is happening on the land involving a hazardous contaminant, or there's a change in the contaminated land, so it's got more severe, for example, or there's an activity carried out that is causing or is reasonably likely to cause serious or material environmental harm, so again, those definitions we looked at last week, then they have to report. There's a duty to report. They also now extend it to local government. So if local government becomes aware that it's being carried out in the local government area, then they have an obligation to notify as well. So you can see the Environmental Protection Agency is trying to make use of people who might be more familiar with the site than they are in getting that information back to them as the regulator so that they know when land has become contaminated, so they can then essentially put it on the register, and we'll talk about that now. So what happens, the land is then included in the Environmental Management Register or on the Contaminated Land Register, depending on what the classification is. And so it will be included if the authority is satisfied that a notifiable activity has been carried out on the land or the land is contaminated. In that case, it's the Environmental Management Registry, and then the second dot point here, it'll be included on the Contaminated Land Register, the CLR, if they're satisfied the land is contaminated and it's necessary to take action to remediate the land to prevent serious environmental harm. So for the purposes of the exam, you need to understand these concepts of land being included on the Contaminated Land Register, what it means for the site and so on. So this is new. They didn't used to do this, so you would buy a property with no prior knowledge of what had happened on the site, of the level of environmental quality or otherwise of the site that you were buying. Now these things have to be listed, and generally speaking, when you buy a land, particularly a vacant block of land or land in an industrial area, you'd be going and doing searches of the EMR and the CLR to see whether or not they're listed as contaminated, because that does change what you are able to do on the site, but it also imposes duties on you in terms of what you have to do with the site. You can't just allow it to continue to leach contaminants into the surrounding area, so that there's a cost imposed. So one of the things that might be required is a contaminated land investigation. So it might be required, it could be required under the Environmental Protection Act or the Planning Act, or it could be provided voluntarily. So there's a couple of triggers that might happen there. And one of the things that it includes is a thing known as a site suitability statement. And a site suitability statement is very interesting. So what it does is it's based on an investigation of the land, so an audit. And it says, is the land contaminated? If it's contaminated, what is the extent of that contamination? Is there a site management plan in place for the site? And what uses or activities are suitable for the site given that investigation? So you might have a site suitability statement that says, this land is contaminated with lead, therefore it cannot be used for residential purposes. So you can still at that point use the site for residential purposes. But you could also remediate the site to a level that you could then go and get it reviewed again or audited again and get a site suitability statement that said perhaps that it was suitable for residential purposes. So you're not stuck with just what you're given. You can remediate it to a level where it's able to be used for a different purpose. But certainly when it's first put on that register, it's put on the register with an explanation of the extent of the contamination and what that means in terms of the safe uses for the site. So a site management plan is a fairly critical way of moving forward in terms of remediating the site. So normally the authority would require that a site management plan is prepared. And that's really to make sure, like I say, that the site moves forward and is remediated rather than just being left in a contaminated state. There's a couple of things for how the site goes on the land registers. You can imagine it makes quite a big difference in terms of the value of the property between having something on the register and not on the register. So they have to have a little bit of equity and due process that goes on. So the authority gives the owner written notice. The owner has time to respond and can make a written submission. And then whatever decision they make, they have to notify. They have to notify the owner, the local government, because obviously they don't want the local government approving a use of the site that's inconsistent with its contamination. Okay, so they have to notify the local government so the local government knows not to go ahead and say, yes, you can have a residential use on this site. And they also have to let the registered mortgagee know. So they have to let the bank know that the asset that their debt is against is affected by contamination, and so on and so forth. And then the registrar of titles is notified. So you guys, you remember you were given the land title search for the Beachmere property. So the land title search would normally list whether it was contained on the contaminated land register, so that people, when they were buying houses, were aware of the fact. So the Register of Titles is required to maintain records showing that the site's located on the contaminated land register. Again, this is all fairly new. So in the past, it was called, it still is known as buyers beware. Property lawyers love talking about buyers beware, and then they chuckle and they think it's very clever. But that's what it was in the past. Once title passed to you, you were stuck with whatever you had purchased. And if it happened to be a contaminated site with an incredibly expensive environmental protection order over it to remediate the site for X million or whatever it was, you bought the site, buyers beware. But now there's a little bit more notice given on these title searches for the fact that these things exist and they affect the property. People who are leasing the site, so occupiers, have to be notified as well. Again, this is new. So when they enter into a lease, they have to be told that they're entering into a lease for a contaminated site. Proposed purchasers have to be notified now, and if they don't comply with it, then the buyer may rescind the agreement. Basically means revoke the agreement so it doesn't exist anymore. So if the owner does not comply, I'm taking you down to that bottom paragraph. If the owner does not comply with this, the buyer may rescind the agreement by written notice given to the owner before completion or before possession, whichever is the earliest. So what that means is once you move into the site, so you take exclusive possession, or once you officially complete, i.e. title transfers to you, you can't rescind. You can't hand the title back and pretend that the contract never happened. So once that happens, the legislation can't help you. But up until that point, under the Environmental Protection Act, you can get out of that contract and you can rescind the contract. So, so the important thing is that when an owner is selling the site, they have to give particulars of the fact that it's been recorded on these registers. They have to tell them that if there have been any notices issued, like cleanup notices, and any other orders that have been given. So basically full disclosure, so they know exactly what they're walking into from a financial point of view. So what happens once it's on the register? Well, one of the things is there needs to be a restriction on what is the approved use of the land under the Sustainable Planning Act. So what it says is a local government must not, under an approval or any other authority under the Planning Act or any other act, allow the use or development of the land in a way that contravenes a site management plan for the land. So they're trying to get that consistency there between what a local government is allowing to take place on the site and what the Environmental Protection Agency is attempting to regulate on the site. So there's a little bit more synergy going on there. So what if the site's remediated? So if the authority receives either a site investigation report or a validation report which says, look, here's a site suitability statement stating that the land is not contaminated and it's suitable for any use. If that's the case, if they get that, they are obliged under the Environmental Protection Act to remove the particulars of the land from the land register, be it the EMR or the CLR, whichever of those registers it is. They're obliged at that point to completely remove it from the register. If the site suitability statement is just changing the type of use that can carry on the site, so it's still contaminated, but it's just inched its way up in terms of the number of uses that it's permitted to have given the contamination, well, then they are just required to amend that description on the site in terms of what the suitable uses are under that site suitability statement. So everything hinges on the site suitability statements, and those are not done by lawyers. Those are done by the consultants out in the field, by the auditors and the environmental consultants. So, you know, a lot of you will find yourself doing this sort of work when you go out into the profession. So it's important to know, first of all, that you have an obligation to report. That's quite important to know. But also understanding the repercussions of what you report in terms of how it then impacts on what can happen on the site and what the regulator does in relation to the site. Okay, so we're going to take a 10-minute break, and when we come back, we're going to talk about the powers of the environmental agency, and we're going to look at a case study that the Department of Environment gave to me, the Innisfail fish kill, and we're going to use that to look at the powers of the department in terms of investigating and prosecuting examples of pollution events. And if any of you have questions in the break, come down and ask me. Alrighty, we'll get started again, and I will move through these fairly quickly because we'll have an opportunity to talk about them, particularly the prosecution guidelines in more detail when we do the prac. So what you'll do is you'll do a scenario next week based on a prosecution in Mackay, where you will look at it from the point of view of the developer, and then the following week you'll use the same facts and look at it from the point of view of the regulator, using the prosecution guidelines to advise your supervisor on what would be the best course of action. So it means you get to investigate the legislation from both sides, which will help you in the exam, but also it's helping you with your statutory interpretation, with presenting your conclusions, and all skills that you need for the exam. So back when I was at QUT, we had Amar Amir from the Department of Environment come out and give a presentation on the powers of the department and really the sort of things that they wanted industry to know about as well. I mean, he was looking at it from the point of view of here are third-year law students, so they were very close to graduation. They're going out into the field. What do they need to know? So it was very interesting just seeing the things that he considered sort of critical in terms of what he wanted that student base to know. And I think they're even more critical in terms of the students here in this course, because you're going to be the ones on the ground dealing with these sites. And I think it's always really important to think about, well, what are the objectives of the department? What is it that they're trying to achieve here? And when we looked at things like the coal seam gas and the mining, in many ways, education towards compliance is probably their number one tool that they're using. But they know that they need to have a full suite of mechanisms available to them in order to secure compliance for people who just aren't going to respond to education and chit-chat. So this case out at Innisfail, there was a drum of endosulfan, so insecticide. It was pierced during loading, and there's the evidence that was collected by the Department of Environmental Services, so there's the photographic evidence. You can see down the very bottom of the can at the front there, the big piercing in it. Insecticide spills everywhere, and they say, what do we do? Now, obviously there are many things they could have done. What they chose to do is get out a hose and hose it down the nearest drain. They figured, no one could see it, wasn't a problem, don't see, don't tell. What they didn't realise was that people were going to see the dead fish floating to the surface, and there were hundreds of dead fish throughout a tidal drainage channel within Innisfail. And of course everyone pointed the finger at the nearest loading site, and it was soon found out what had caused the fish kill. So obviously there's an immediate take-home message there in terms of, when you have a chemical spill on site, even if it appears to be minor, don't hose it down the drain. Contain it and take reasonable efforts to prevent it from running down the nearest drain. Of course, think back to the offence provisions we looked at just today. The offence of placing a contaminant either near to or into a stormwater drain. So there's an actual provision there that's directly aimed at this sort of behaviour. So we've looked at the Department of Environment toolbox a few times. It's a reoccurring theme across this course, this idea that there's a tiered approach, a tiered response to how the regulator can respond to environmental harm. And I just wanted to put it back up there for you just to remind you that we talk about this toolbox for a reason, because it's the way that the legislation has been designed to give the department a range of tools that they can call on when they're talking about responding. But of course we want to look at specifics. We want specific examples from the legislation, and I'm going to take you to a few of them now. One of the things to remember, this is the escalation path. So this is looking at how people respond to harm and fault. It's a really good rule of thumb. It's you again would expect to find an exam question on something like this. This idea of when there's a certain level of harm, a certain level of fault, but zero remediation effort. What do you think? Are they more likely to be prosecuted? However, when there is a low level of harm, there's a low level of fault, but a high level of remediation effort, well, then you would find that they would be less likely to be prosecuted. Okay? So high level of harm, high level of fault, and low level of attempt to remediate what has happened, more likely to be prosecuted. Okay? But put it in reverse, where it's a low level of harm, low level of fault, and they've made an effort to remediate when they've realized what has happened, you're going to find that the department will deal much more kindly with them and would be less likely to prosecute. So one of the tools that the department uses is this idea of direction notices. So things like they are operating without an environmental authority. If they're causing an environmental nuisance, or they're contravening a noise standard, depositing water contaminants, so on and so forth, you're going to find that the ability to issue a direction notice is a very convenient tool for the department. So they can, the aim of the tool, so you can see in the middle of the slide here, the aim is it's used to provide an opportunity to remedy the matter where it's capable of being remedied. Okay, so this is the sort of thing where you can say to them, okay, we want you to stop causing the environmental nuisance. So we want you to stop the classic examples are when you're operating piggeries or chook farms, things like that in residential areas. It's causing noxious fumes and so on. And you can give them a direction notice saying, we want you to cease causing this environmental nuisance because it's capable of being remedied. There are measures they could put in place to deal with the noise, odours coming off the site, or the noise or odours coming off the site, and so on and so forth. How do they do it? Well, they can issue a written direction requiring the person to remedy the contravention. The time that they give them to comply with the direction is going to take into account what action they're being required to take, the risk to human health or the environment, and how long the person has been aware of the contravention. So if this contravention's been going on for 12 months, they're not going to give them another 12 months to remedy it. They're going to say, we want this remedied within a month, for example. But if it's something that is very high risk to human health or the environment, they may say, okay, 24 hours. You've got 24 hours to comply with this direction notice. The offence provisions that come with this down the bottom, so failure to comply, if you willfully fail to comply, well, then it's 1,665 penalty units. Otherwise, it's 600 penalty units. And we've seen that before in our offence provisions. If you do something willfully, so if you do it recklessly, without sort of any regard for the consequences, then you're much more likely to get a severe penalty imposed on you. One of the other tools, so this is slightly higher up on the hierarchy, is the environmental protection orders. So what's the aim of these? Well, the aim of them is that they're used to secure compliance with duties under the Act and with any requirements issued under the Act. So, for example, a condition of approval. If there's non-compliance with a condition of approval, then they would issue an environmental protection order, which would order them to immediately comply with that condition of approval. They might require them to carry out an evaluation of the site, an audit, to put in place a transitional environmental program. We'll talk about that in a minute. And also, it's where they've breached conditions of authorities, conditions of consent. So these are fairly serious. An environmental protection order is a fairly serious mechanism. The standard criteria has to be considered before they decide whether or not to issue the order. So again, you'll remember I told you it's important to understand the standard criteria. So if you haven't downloaded and printed out a copy of that, make sure you make a note to do so. One of the things is it can be issued to related persons of companies. So if the company itself is not responding to the environmental agency's warnings, then they can go to a related company, a related person, and issue the environmental protection order directly to them. And again, you'll remember me talking about the Clive Palmer amendment, as it's fondly known, which was designed for exactly that purpose, so that you could chase people who were financially benefiting from the company and issue these environmental protection orders to them and say, you've got deep pockets, you're related to this company and you have financially benefited from this company, you pay for the remediation, you pay for the compliance. It's unusual. It's unusual across Australia, and it's certainly unusual to sort of see that very long arm of the law, as they call it. But it's been put there in response to the fact that these companies are going into liquidation, and the state government is left footing the bill. You can see the penalty unit for this compared to the one before. Remember the page before, it was 1,665 penalty units for non-compliance. Maximum penalty here is 6,520 penalty units, or 5 years imprisonment, okay, for willfully contravening an order. So if you willfully do not comply with an environmental protection order, you could face imprisonment and you could face a very, very hefty bill. Another tool that is used here, and this is particularly for contamination incidents, pollution incidents, that sort of thing, is a clean-up notice. So a contamination incident has occurred. It's likely to cause serious or material environmental harm, so it can't just be left. You know, it's almost like the Sydney Harbour example, only much more immediate. You know, we know it's happened. We've identified that this contamination incident has happened, and we've said, right, it's either going to cause serious or material environmental harm, or it's likely to cause the land or any other land to become contaminated land. And this was one of the things I was talking about at the beginning, about how these plumes of contamination make their way through the underground soil system and the groundwater system and start contaminating nearby houses, and usually houses that are downhill from the contaminated land. So it often doesn't just say in situ on that one site. You often find it has the risk of contaminating other properties. So in a case like that, they could issue a clean-up notice. So it's one of the tools that the Environment Protection Agency would have to issue a clean-up notice, and it can be issued to what's known as a prescribed person. Now, that's quite broad. It could be either whoever caused the contamination incident in the first place. It could be the occupier of the place, so that's the person now under a lease. It could be whoever owns it or controls the site. But they can also start going upward through the hierarchy. They can go to the parent company. They can go to the executive officer, and so on and so forth. So if they issue it to the occupier of the site, let's say it's being leased by a manufacturer, and they don't respond, they can then go to the owner, who would be someone entirely different, and say, well, you own the site, you clean it up. And if that doesn't work, then they can go to a parent company and so on. What's the aim of this? The aim is to take action to prevent or minimize contamination. We want to see that these sites rehabilitated, restored, or it may simply be a case of assessing the nature and the extent of the environmental harm that's happened from the contamination incident. One of the things that the legislation says is the time to comply must be reasonable in the circumstances. But also, as I pointed out, they can issue it to more than one person. So it can be issued out to multiple people at the same time if they feel that that's the most efficient way of getting action. What happens if you don't comply with a clean-up notice? Well, the legislation says you must comply unless you have a reasonable excuse. And some of the defences that you might be able to show in a proceeding against you is that you're not a prescribed person, so you don't meet the definition of prescribed person under the Act. You could try proving that the contamination incident was caused by a natural disaster as defined under the Act. You might be able to point to the fact that the contamination was caused by a terrorist act or other deliberate act of sabotage by someone other than the recipient of the notice. And you might say, and, notice when we interpret there, it's an and at the end of that, and the recipient had taken all measures it would be reasonable for the recipient to have taken to prevent the incident, having regard to all the circumstances, including the inherent nature of the risk and the nature of the recipient's connection with the incident. So it's a little bit like complying with the general environmental duty. Have they taken all reasonable measures given the nature of the risk and given the nature of the incident? And of course, the legislation, just down in that small dot point here, the legislation has to put in place a mechanism for allow whoever receives this notice to go and carry out remediation and cleanup on the site when they don't own the land. Okay, because they don't have, without the legislation, they don't have a right of access to go onto the site to clean up the land. So this has been historically a problem that we then encountered, was the person with the deep pockets was not the person who had consent or a right to enter the land and actually start interfering with it. And so now there's a mechanism that allows that to take place. And that's section 363J that's down there at the bottom of that slide. One of the other things that they can use is a cost recovery notice. One of the things you would have, I think, picked up on across this course so far is money matters. And one of the difficulties of environmental activities or environmentally risky activities is when we start talking about cleanup costs, we're talking about significant amounts of money. And so in this case, if the recipient fails to comply with a cleanup notice, then what may happen is an authorised person or a contractor from the Department of Environment may go in and clean up the contaminant instead. Now, that could be a very expensive exercise, but it has to be done because of the risk to human health, the risk to the environment of serious or material environmental harm. So the government itself has a duty of care here. They can't just leave it because they are aware of it. But at the same time, we're talking about large sums of money incurred in doing so. So what they can do is issue what's known as a cost recovery notice. So that then goes to whoever was the recipient of the cleanup notice, and it covers any costs reasonably incurred in taking the action that was specified in that cleanup notice, as well as monitoring compliance by the recipient of complying with the cleanup notice. So that's an interesting mechanism. So they can then recover the costs of monitoring whether or not the recipient complied with the cleanup notice. If the contamination was not caused by the poor soul that received the cleanup notice, okay, let's say, for example, it's the owner of the land gets the cleanup notice and is the one that has to go and incur all the costs of cleaning up the land when it was someone else that caused it, the legislation allows them to recover that money as a debt due and payable from the person responsible. Now, I don't know if you know what a debt due and payable means, but basically it means you can go to a local court and claim it, like a magistrate's court, and claim it as a debt, rather than having to start going through and proving causation and negligence and all the rest of it. It basically just says whatever that lump sum is, whatever it costs, that's a debt due and payable. You just prove that there's a sum of money owing to you, and then it's just a question of trying to get recovery of that money through normal mechanisms, so normal recovery, debt recovery mechanisms. So you can see that there's a lot of detail in how they're trying to think of all the different scenarios of how do we get these sites remediated. You can almost see these as a response to the type of problems we saw with the Sydney Harbour situation. So nobody wants to see a scenario where all of the companies that have benefited from the site disappear through old age and liquidation and all the rest of it, and then the government's left to foot the bill with no ability to seek recovery of those costs. So the Queensland government has attempted to be on top of that by having these mechanisms. One of the other very, very interesting mechanisms that the Environmental Protection has, and this applies to everything we looked at last week as well, so keep this in mind whenever you're thinking about the offence provisions from the lecture, the last lecture that we did as well, sorry, that was before the mid-semester break, is this thing known as a transitional environmental program. Now, the aim of it is to reduce the harm caused by an activity or to transition to a better environmental standard. Okay, so what it does is it provides protection from a prosecution under the Act. So what you do is, let's say you run a factory and you become aware that there was a large quantity of material leaching into the ground. So there's a contamination event going on. You're not complying with your conditions of approval. You know that you're causing environmental harm and you know you are at risk of prosecution. The smart ones at this point voluntarily go to the Environmental Protection Agency and confess. They fess up and they say, bit of a problem. Appears like our processing standards on the site of leading to this problem. We're going to try and fix it. It's going to take time. We need to get in new equipment. You can imagine economic arguments would be run. Obviously, you need to show a willingness to change, to transition. But what this does is it protects you. So if you submit that, let's say you submit a full document outlining all the things that have happened on the site, that notice that you give the Environmental Protection Agency cannot be used as evidence against you in any court for prosecutions. So the Environmental Protection Agency is barred from using it as evidence against you. And what happens is this transitional environmental program is put in place and it details how you will transition whatever activity it is you're carrying out on the site to a point where it will be complying with the conditions of the environmental authority or your development condition or whatever the conditions are. So it's that movement towards better environmental practice. It has to be approved by the environmental agency, so it's not automatic. You don't just put the notice in and automatically know you're getting a transitional environmental program. But generally speaking, it's quite well regarded by the department. But if the transitional program is going to take more than 3 years, so if you've got protection from environmental prosecutions for more than 3 years because you're under a transitional environmental program, there's now an obligation for that to be publicly notified before it's issued. And then again, because there's a general theme here about money matters, the authority is able to claim any costs or expenses that it incurs in monitoring or securing compliance under a transitional environmental program. So they help put the program together, they go out and they audit the site, they educate, all these things, and then all of those costs are able to be recovered from I was going to say the client. They're not the client, but it's essentially that sort of relationship. They're helping them out. They're agreeing not to prosecuting. They're helping them to improve their environmental performance, but they also are getting those costs back. And of course, the company is usually quite willing to pay those costs because they're avoiding a prosecution. Now, it only protects them if they comply with it and they do actually improve their standard of environmental performance. If they don't comply with it, then all bets are off and they're back to being prosecuted again, except for that original notice. The original notice where they go to them and voluntarily say, hey, we need a transitional environmental program here, that still can't be used against them. And of course, one of the final tools, this is the tool of last resort because it is expensive, is going to court and actually taking proceedings against someone to restrain breaches of the Act. So you can take proceedings to either restrain an offence or a threatened or anticipated offence against the Environmental Protection Act. It can be taken by the Minister, it can be taken by the Environmental Protection Agency, it can be taken by someone whose interests are directly affected. Usually that's someone with either their property rights are affected or their economic rights are affected. Okay, so those first three, Minister, Environmental Authority, someone whose interests are affected, that's your normal court procedure. That's the normal sort of people who have a right to bring a case. What's less traditional is this idea that someone else can go and put their nose in and start pointing that perhaps there's been a breach of the Act and something should be done about it. And that someone else, under the Environmental Protection Act, has to have the leave of the court in order to bring proceedings. So someone else with the leave of the court, even though they don't have a proprietary interest, so they don't own property that's been affected, they don't have a material or a financial interest, or in fact they may not have a special interest in the subject matter of the proceeding, but they can go and apply to the court to have leave to bring an action. And if I've remembered correctly, yeah, this is telling us what cases they'll give leave for someone to bring what's known as a public interest proceeding. So this is the environmental groups, the community groups, the residential associations, people that have realised that something is going on that's not being prosecuted by the minister or the department, and they choose to do something about it themselves. So the court has to be satisfied of a number of things. There's 3 dot points up there. Number 1, is it in the public interest that the proceedings should be brought? Secondly, that the person has to have gone to the minister with a written notice or the local government asking them to bring a proceeding, and they failed to do so. Okay, so they have to have requested that someone else take this proceeding first. And also they have to show that they can adequately represent the public interest in the proceedings. And so that's why it's normally these community associations or environmental organisations that are able to stand up and say, yes, we can represent the public interest here because that's why we've been created. That's the purpose of this group. So the Environmental Defender's Office is an example of that. However, the court under the Environmental Protection Act can grant leave subject to conditions. Now, they could require that they give security to the court for any costs that may be awarded against them from the proceedings. So security is like a virtual bank loan. So you're going to go to the bank and say, I need a security to give to the agency, or to give to the court, my apologies, to the court for $5,000. So at that point in time, it's like you have to apply for a loan for the bank for $5,000. They give you a security, and then you take that to the court and you say, here's my $5,000. So you need to be in a position to be able to A, borrow that money, and B, pay it off. Okay? So sometimes if the court is concerned that whoever is bringing the proceedings doesn't have deep pockets and might not be able to pay any costs awarded against them, they'll make them give security to the court first. Now that could often knock out someone from potentially bringing an action because they don't have the financial capability to do it. They might ask them to give an undertaking, which is another form of financial instrument, about any damages that might be awarded against them. Same concept. You can see they want to make sure that there's going to be money there if the order is made against them. Now, the potential orders of the court is very interesting. So, under the Environmental Protection Act now, there's this quite a wide range of options that the court can order. It's not just a sort of environmental protection order. They can have a rehabilitation or restoration order, which is the first one up there. Now that requires the person to take action to rehabilitate or restore the environment that was caused as a result of the offence. Okay, so you know it's got to be reasonable, but it's a direct order of the court telling them to rehabilitate. The second one is known as a public benefit order. So they might make them carry out some sort of project. It might be an offset project, it might be some sort of park reserve, it might be some sort of education, community centre. So it's a cost thing, it's something that costs them money, and it's something that's a specified project that they have to pay for. Sometimes they do things like they will invest in research into koala habitats or research into threatened species. So they'll give money to another organisation to go and carry out a project for them. But it will be the court will say specifically what they have to do. The next one is an education order, making them carry out an advertising or education campaign. So there's a little bit of naming and shaming there. They normally require them to put it in all the leading newspapers, and it must be a minimum of like a half-page spread. It must identify the fact that they have breached the Act, that steps are being taken to remedy the harm caused. So it's to make sure that the public is aware that this company has breached the Act. And that naming and shaming can actually be quite successful because shareholders don't like to see companies that they're investing in being named and shamed on, a half-a-page ad in the Courier Mail. So it affects their value of their shares, and that hits their bottom pocket. So education orders can be very effective. Monetary benefit order is another sort of thing, this idea of paying an amount of money. So if the person, what was the one we looked at? Remember the one where that poor guy didn't read the maps, didn't read the plans properly, and he went and cleared the mangroves and wasn't meant to, and he was going to benefit by X million dollars from having this marina in place and having cleared these mangroves. Now, a monetary benefit order requires them to pay a sum of money representing what that financial benefit was for them breaching the act. Okay, so it's meant to take away that financial benefit that they were going to get from breaching the act. Almost this idea of giving us a level playing field, putting us back to where we were before the harm. And then finally, there's a notification order requiring them to notify a class of persons and so on that they've carried out this breach of the legislation. If they fail to comply with the court order, then the environmental agency can go and carry it out. So they can go and put the newspaper ad in on their behalf, and then they just go and recover the costs from them, again, as a debt due and payable. And then, I think this is the final tool. Let me just double check. Yes, the final tool is known as enforceable undertakings. So this is what often happens is once the agency has decided to prosecute, so we're normally ready to prosecute, and they may even be preparing to go to court, preparing to go to trial, the wrongdoer may decide that this is all looking a little bit risky, and instead of proceeding to trial, would offer to give the authority what's known as an enforceable undertaking. And so what they would say is, look, we acknowledge that we have breached the legislation, and in return we agree to, and they would basically agree to rehabilitate, advertise, make a payment of money to a local conservation group. So the sort of things that the court would probably order anyway. But what are they avoiding by doing this? They're avoiding having a prosecution awarded against them and getting a black mark on their name in terms of their environmental performance. So the authority has a discretion whether or not they accept them, but it's an alternative to prosecution. And if the authority accepts an enforceable undertaking, they then can't proceed to prosecution. So it's an alternative. So they have to then discontinue any prosecution that they have against the individual if they accept the written undertaking. So these enforcement guidelines, these were the February 2016 ones. They're the latest ones. I've given you the link there, so make sure you download them and print them. You'll need them for the week 10 prac, but you'll need them for the exam as well, so make sure you get a copy, get familiar with them. So these guidelines tell us when the Deputy Director General of Environmental Services and Regulation is going to decide whether or not to prosecute. And the decision is based on, one, whether the available evidence provides reasonable prospects of successfully obtaining a conviction, and if so, whether it's in the public interest to exercise that discretion to commence a prosecution. So you can see it's not just, is there sufficient evidence to get a successful prosecution? That in itself is not the full decision. It also has to be shown that it's in the public interest to go ahead and exercise that discretion. And there's a long, long list of things that will be looked at in deciding whether or not it's in the public interest. And I'll get you guys to look at that more closely when we do the prac. But some of the things are things like the seriousness of the offence, the potential harm to the environment, any mitigating or aggravating circumstances, the degree of culpability of the alleged offender, so how much are they at fault, the availability and effectiveness of any alternatives to prosecution. So remember, we've talked about some of those alternatives today. Has the offender been dealt with previously without prosecution? Is the breach a continuing offence? Is it a second offence? But they're also going to look at things like the length and expense of a court hearing. So if they could get if they can get the same undertaking and the same outcome without the length and expense of a court hearing, then these guidelines are pointing to the fact that that might be a preferred way of acting in the public interest. So it may not be in the public interest to launch into a very long and expensive court case just because you have the available evidence, if in fact you can achieve the same outcome using an enforceable undertaking or some other mechanism. I put this slide up in one of the earlier lectures, but I thought it was worth just reminding you in the context of the enforcement guidelines. What do you do if the department comes knocking? Make sure you get those lawyers involved. And we've talked about legal professional privilege attaching to discussions once the lawyers have been briefed to advise you on liability. Make sure you cooperate fully and work willingly with the regulator. Fix the problem promptly. So the scenario today of not mentioning to the Environmental Protection Agency that the contamination incident had occurred, but simply hosing the pesticide down, or sorry, the insecticide down, no, it's pesticide, sorry, down the drain, not a good idea, okay? Doesn't meet my list of what to do when the department comes knocking, and clean up, remediate, restore. The agency may take this into account in deciding whether or not to prosecute, and obviously you'll have a much deeper understanding of that once you've read through the prosecution guidelines. So, to just sort of wrap up, so looking at the case study, the second one that we looked at after the break, so what offence, if any, has the company committed, and how did the regulator respond to the situation? Well, one of the things it did was it used its powers under the Act to gather information as its first port of call. So it had a power to enter the place under a warrant. Okay, it had to get a warrant to enter the site. It had a power to require answers to questions. And it could also seize evidence. So it took things like timesheets, standard procedures, training records. So it was looking for evidence of what were the standards of environmental training and things like that. Again, we talked about that when we looked at the general environmental duty. How do you show compliance with that? Well, one of the ways of making sure that all of your officers, from the CEO down to whoever's on site, have got adequate training in terms of what to do on site. They also took computer evidence. They looked at online timesheets, they took pay slips, they took emails, everything that had been written about the incident was able to be taken and used as evidence. Why? Because it wasn't subject to legal professional privilege. If they'd had lawyers involved in those email correspondence between them and the lawyers about it, for example, would not be able to be used as evidence by the environmental agency. And they also took telecommunications information, so they got phone records of the day to see who rang who after the incident occurred. They laid charges against both the individuals who hosed the chemical down the drain because they failed to follow cleanup procedures, but they also laid charges against the employer because they said they had failed to do all that was reasonable and practicable to ensure that the staff had sufficient training, to ensure they had sufficient processes and equipment to respond to the chemical spills. So there was no mechanism there to manage the risk. So you can see that as a clear failure to comply with the general environmental duty. And so they were found to be in breach of Section 437 in terms of unlawfully causing serious environmental harm. So what were the outcomes? Well, environmental protection orders were issued, both to clean up and to rectify. They took the prosecution against 2 individuals and the company. And one of the outcomes was they made them pay for education adverts in both the Courier Mail and the Innisfail Advocate, paid for by the company, outlining both the fact that they'd been prosecuted and the fact that industry as a whole should remember that they have responsibility for harm caused from pollution incidents. And you can see there's an image there of the examples of the fish kill that resulted from the incident. This is an example of the type of media release that we saw following the conviction. It says transport operators have been warned over carrying toxic chemicals, with the Queensland carrier left with a $174,000 bill for an accident that killed more than 200 fish. Both the transport company and the employee pleaded guilty in the magistrate court. Company was fined $25,000. Anson was fined, that's the individual, was fined $2,800, and both had to pay $6,000 for the investigation costs. And then the company also contributed a further $125,000 to help with clean-up efforts, and committed $10,000 in education advertisements on the local media. And so the minister in this particular example is using it as an opportunity to warn all transport operators that they need to be vigilant about how they handle toxic materials. So you can see they were trying to use it to educate the industry as a whole, to turn it into a positive rather than it simply being just about prosecuting one individual. So it was more of a warning to everyone else to step up their game. Okay, so any questions? No? All right, well, that's all I've got for this week. Next week, we're going to be looking at the Commonwealth EPBC Act. Yep, just remember that we're starting those pracs for the exam next week. And again, just a reminder about the discussion board closing on Monday at 4 p.m. So make sure you get your questions in onto the Blackboard site before the discussion board closes. All right, and good luck with your assignments.